Up next, I'd like to introduce Lisa Soto. For those that don't know who she is, she's actually a world-renowned data privacy lawyer that's won many awards. She's incredibly experienced, has a tremendous amount of knowledge and expertise around the new SEC guidance. She speaks to lots of boards and provides them with guidance on how to think about cybersecurity. So I'm real honored to have Lisa here today to talk to us a bit about what she's observed from a SEC guidance perspective and share some of the learnings that she provides to boards of directors. So please welcome me and join me in welcoming Lisa Soto.
Thank you. All right. I am delighted to be here. For those of you at the edges, if you want to come on in, please do. I'm also happy to take questions as I go. So, just shout. The lights are bright. So wave at me if you have a question. This is an area that is really stymieing legislatures globally. You've heard more than you want to know or we can even comprehend about the cyber risk out there. So, if we can barely comprehend it, you can imagine how legislators and regulators are thinking about this issue. And there really is some bit of paralysis around this issue. But all hope is not lost. There have been some highlights over the last couple of years that we'll talk about today. And I think, I think we're going to be seeing just a huge amount of interest from legislatures and regulators globally to try to understand this space enough to pass law or issue rules in this space. What am I pointing to? There. Okay, just to give you a sense of my perspective, we have 35 privacy and cybersecurity professionals around the world in New York, DC, London, Brussels, and Beijing. We represent mostly private industry, some governments as well. And we represent companies across industry sectors. And that's really important because this truly is a nascent area in every regard, but certainly in the law. So you really do need to analogize from industry sector to have any sense of what's going on in the market. If you're very interested in this area, I would commend to you our privacy blog, huntingprivacyblog.com, where we post on privacy and cybersecurity issues from all over the world. And no privacy practice would be complete without a Twitter handle. So there you go. All right, we're going to talk a little bit about the SEC rules in the United States. What's going on there? What does the landscape look like? Actually, before that, I'm going to hit U.S. data security rules, and then we'll talk a little bit about the EU, where there have been very significant developments, and then hit the role of the board. So in the U.S., the Federal Trade Commission is the primary enforcer with respect to data security. And they enforce under a very, very old rule passed in 1914, Section 5 of the FTC Act, that prohibits unfair or deceptive trade practices. So this very amorphous phrase has been translated into the enforcement hook for data security violations. And they're very sophisticated now. They're really very well trained in this area, and they have technologists as well on their staff to help them through some of the knottier issues. With respect to financial data, the Gramm-Leach-Bliley Act has what is known as the Safeguards Rule for financial institutions, and it's pretty it's an elegant little set of regulations that essentially says you have to have a comprehensive written information security program in place. It needs to be comprised of administrative, technical, and physical safeguards. Those of you who follow this space know that that's a litany that we've heard over and over and over again in legal requirements. Similarly, in the health arena, HIPAA has a security rule that requires administrative, technical, and physical safeguards. Again, the same litany to protect protected health information. And those are fairly old law rules now. One is a regulation and the other is a law with sets of regulations falling under it. And they're really ancient. These were issued in the early 2000s. So you can imagine in the information security space how much past these rules we have now gotten in our current environment. There are also industry sector rules more narrow, like FDA rules, energy sector rules, and then we'll talk in greater detail about the SEC rules, which affect all public companies and also have a deep impact with respect to entities that fall, financial institutions that fall under their jurisdiction. The states. The states have really been the leaders in this space. In the absence of much federal regulation, the states have led the charge. And yes, there are some data security laws in the states, and those are, of course, very tricky because if every state issued its own set of security requirements, how would we'd be completely paralyzed. We couldn't possibly operate. We'd all shut our doors. But they're all very rational, and there are some that are more stringent than others, but they're pretty rational so that they can be rationalized across organizations and across the states and not risk triggering the Commerce Clause. The most important state requirements, in my view, are the state data breach notification rules. Those have gone a long way towards changing the shape of our security environment, not because they mandate security, but because they deeply embarrass, and of course there are other consequences as well, but they deeply embarrass companies that have to go out there and stand on their roof and raise the red flag to say, we've suffered a data compromise, sorry, your information is included. So that has been a very significant driver of data security in this country. And we now have, for the first time, 50 state laws. It was 48 for a while and 46 for a while before that. We now have 50 state laws plus 4 jurisdictions, U.S. jurisdictions, Guam, Puerto Rico, U.S. Virgin Islands, and D.C., that regulate in this space and require breach notification where there's a compromise of data. And then we have, again, industry sector type rules like the New York Department of Financial Services cybersecurity rules. Anybody subject to that? Okay. Well, you know that it's a pretty stringent set of rules. And by the way, that's being mimicked. I put it here not because I expect a lot of people to be subject to this, but because we're going to see it showing up in other states as well, and it has already been mimicked by the model insurance rules. Model, often picked up by states. The new California Consumer Privacy Act, is anybody struggling with this yet? All right, you will be. The CCPA just came into existence it was passed on June 28th in California. It is not limited to California. It is a very onerous set of privacy rules that will absolutely change the shape of privacy in this country because it applies to any company over a certain threshold that has California consumers defined as California residents. So if you do business with California residents, there you are. Or if you have California offices, yes. Is the CCPA going to be amended? So it was already amended once, and it passed, by the way. It was supposed to be a ballot initiative. The legislature took it over, passed. It dropped on June 21, June 21, and then it passed on June 28th. So as with any hastily passed law, it is deeply flawed. There has already been one set of amendments. There will likely be others. But I would not look for radical changes. I don't see any state legislator taking it on to say, well, I'm going to weaken privacy protection for my constituents. So I think that's going to be a tough slog. Anyway, the CCPA is mostly about privacy, but it does allow now for a private right of action with statutory damages for data breaches. So this is very important now in the security space as well. And of course, industry standards are also critical in this space, like the PCI standard that has gone a long way toward changing the shape of payment card security. Yes?
Can I just ask briefly about how the state regulations fit into the federal regulations in terms of jurisdiction and who would have oversight and enforcement?
Yeah, great question. How does the state scheme fit into the federal scheme? Well, we have a complete cacophony in the United States. It's truly a morass. We have federal rules that often don't preempt the state rules. So we've got all these state rules. You have to comply with all of them. There is not, look, there's an effort afoot right now to try to pass a federal law that would preempt state laws. But I testified before Congress in 2006, and I testified that the breach of the VA hard drive. Anybody remember the VA hard drive that was stolen from an employee's house? my testimony was I said in my testimony that this was the cataclysmic event that would get us over the edge to a federal breach notification law. So could I have been more wrong? Right? Do not look to me for the crystal ball, which is it's quite extraordinary that we have 54 U.S. jurisdictions with these laws, but we can't get our act together to pass a federal law in this space. So we'll see what happens there. And there's also a move afoot to pass a federal privacy law, but boy, is that hard. The devil is in the details here. The details are very significant. So we'll see what happens. Okay, let's talk about the SEC, because there's a lot happening on the SEC front. A little bit of history. We think about the SEC as having become really active in recent years, but they were active before as well. So the SEC has not been dormant in this area. They have taken action in more than just the past several years. In 1998, the Office of Internet Enforcement was formed, and in '99, the Gramm-Leach-Bliley Act was enacted, and the regulations, including the safeguards rule, followed within a year or two after that. Most SEC enforcement actions have resulted from Gramm-Leach-Bliley Act safeguards rule violations. But there is certainly activity on the disclosure front as well. So we're seeing now quite a bit of activity on that front. In 2011, we saw our first staff guidance specifically focused on this issue. And essentially what happened there is that the staff reminded the regulated community that they needed to make sure that they were considering cybersecurity risks and incidents in their disclosure. So that was a good reminder to sort of shake things up a bit. And then in 2017, the cyber unit was created. So clearly an effort to focus on this area. And then in 2018, the commission, and this is a document issued by the commissioners themselves, so more important really than the 2011 document, the commissioners issued their interpretive guidance, and it does give some good tips. If you read it carefully, what you see in it is experience from prior breaches, and it's very easy actually to label each paragraph that breach. Oh, I know that one. Oh, that's a result of that breach. So it's really a lessons learned document that was issued by the SEC. So what does the SEC say in their document? They focus on disclosure by public companies, ensuring that investors have enough information so that they can assess the materiality of the risk, and so that they can understand whether or not they need to think about this issue in connection with companies in which they invest. The SEC tells us that corporate governance disclosures need to describe the board's involvement in overseeing cyber risks. So think about whether the board charter needs to say something about their requirement to oversee cybersecurity risk. The SEC expects disclosures to be tailored, to not be boilerplate. You can't say things like, we may suffer risk of fire, tsunami, earthquake, cyber risk. It's not like that. Cyber is so much more likely to be a risk to the company than these other things, that it really does need to be called out. And for some companies, it's a deep risk that they experience probably 50,000 times a day. The guidance also tells us that we need to refresh our disclosures. So if you experience a breach 1 year and you don't discover it till a couple of years later, you may need to go back and revisit your disclosures for that previous time period and refresh those disclosures. The SEC also warned about insider trading. We have seen that 2 Equifax employees, information security employees, have been indicted because they traded on information. I hate to say it, but this is not news. This is kind of the don't be stupid rule. You can't trade if you have inside information. And in this instance, this sort of inside information is very, very significant. There was not a blackout period put into effect. There should have been probably. And what we're now very cognizant of is thinking about when to put a blackout into effect. Commissioner Stein said this didn't go far enough. You know, I appreciate, she said, that we issued this, this guidance document and everything in it is useful, but we're really reiterating what we said in 2011, and there's really not a whole lot new in this document. And really, we should have gone farther because the depth and the scope of the threat is so much more significant now. And we've learned a lot in 7 years, and we should have taken those learnings and gone further. So, you know, we'll see. This is something to watch going forward. But certainly, there's a huge amount of guidance in the 2018 document that we should all be cognizant of. So, some actions. I mentioned the Equifax indictments. And then Facebook is reportedly being investigated in connection with Cambridge Analytica. And for those of you who have been following, Yahoo settled their action with the SEC for $35 million. By the way, settled a shareholder suit for allegedly failing to disclose this issue earlier that they suffered. They announced in 2016, suffered the issue in 2014. They settled for $80 million with their shareholders. So these get really expensive. All right, let's talk about what's happening globally. And please just raise your hand if you have questions. Yes.
So, you know, in our experience, we deal with a lot of organizations that deal with breaches. And as you were talking about a particular case where there are certain insiders that made trades when they became aware of a particular breach, how do you coach organizations and individuals around when maybe they should or shouldn't trade? Because quite frankly, a lot of individuals that may be responding to an incident may not quite understand the significance of or the materiality of a breach and how it might actually impact the stock. And there's sometimes a question around whether or not that's considered to be insider information or not. Obviously, given the stock price had a dramatic drop in the Equifax situation, you know, I think you could argue that maybe there is a real compelling and material incident in that situation. But I'm just curious what your guidance is to organizations where there are maybe dozens or hundreds of people that might know about a breach but don't understand the significance or the materiality of it, and what are the implications of potentially trading stock?
Yeah. Well, first of all, the first thing I do in guiding a company is I say, call your securities counsel. Who is your normal securities counsel? Let's bring them into the fold, because they're best situated to advise. So that's a very important first step. Putting a blackout period into effect is hard for employees because they can't trade, and they might have counted on that stock to buy a house or pay for tuition this semester for their kid. So it's not an easy thing to do. But look, there are policies that say you can't trade where there's of an issue. So those policies are almost always in effect anyway. These were anomalous situations where these guys should have known better. I think probably training is really helpful, but also we do have to consider whether we need to impose these rules so that they're not getting themselves in trouble by doing this. So, yeah. All right, let's, anything else before I turn to the EU? Okay, let's turn to the EU. There have been really dramatic changes in the EU. So for the first time with the General Data Protection Regulation, is there anybody here who has not struggled with the GDPR over the past 2 years? Absolutely 100% of this room has struggled with it. It's been a real challenge. One of the provisions that is a huge challenge going forward is the breach notification requirement. You all know probably very well that now in the 28 member states of the EU plus the EEA nations, there is a requirement to notify the relevant supervisory authority within 72 hours of a breach, of becoming aware of a breach. So what does becoming aware mean, right? That's the $64,000 question. Did you become aware that Europeans were involved? Did you become aware that personal information was involved? When was that? When did you really become aware of the issue? So there's some play in there, but I was just asked a question last weekend. So do weekends count? And yeah, weekends count. It's not business days. So, you know, this poses just an enormous challenge to organizations because in 72 hours, you know nothing. You haven't even retained counsel, much less a forensic investigator to come in and help you understand what's going on. And there's quite a bit that needs to be reported to the supervisory authority. It's not just, you know, bare bones information. You have to talk about what happened, who was affected, what data was impacted. So there's really quite a bit that needs to be reported. The real truth of it is that we know very, very little within that 72-hour period. So we report what we can, and we may need to amend. We've already handled over 20 GDPR data breaches. So, and you know, we're just one law firm. So that just gives you a sense of what the scale is. And of course, companies are being uber conservative in reporting because, as you all know, the breaches, the penalties for violating these provisions, this provision in particular could be up to 2% of global revenues, and for violating other provisions, up to 4% of global revenues. And you can bet that if you violate this provision and they want to nail you, they're going to find something that will get you to the 4% level. So you need to notify the supervisory authority within 72 hours. And then if there is a high risk, and by the way, there is a risk, a harm threshold of sorts. If there is a risk to the rights and freedoms of data subjects, then you need to report. So really, almost any data compromise will pose a risk. It could be minuscule, but it is a risk. So companies are being very conservative in reporting. You don't have to report to affected individuals, however, unless there's a high risk to the rights and freedoms of individuals. So we have a lot of play in there, and certainly many, many breaches do not rise to the level of high risk to the rights and freedoms of individuals. If you are a data processor, meaning a service provider, your obligation is to notify the data controller. We think of that as the data owner in the United States. And the way to really manage this with data processors is to make sure that your contracts have a reporting period in there, because you're going to be held responsible. Now, you're not going to, as a data controller, you're not going to be held responsible for the moment when your data processor knew, but the second your data processor tells you, that starts the 72-hour clock running.
Hey, Lisa, one quick question. So the Europeans have very strict privacy laws as well, too. So how do you balance that with, you know, the 72-hour breach notifications? Because, like, on the forensic side, and I'm with Mandiant, you know, we try to get in there as quick as possible to help them understand the issues. And then I feel like I'm oftentimes handcuffed with the privacy laws and, you know, what the companies can or cannot do.
And Dave and I have worked together many times, and we have struggled at 1 o'clock in the morning when we've had to put agreements in place as between the U.S. entity and the EU entity to be able to transfer data. So yes, there are many, I would say, counterintuitive conflicts that arise as between the data privacy issues and the security needs of the company. Yeah. You know, there it is. And you know, this is just a problem, I think, with European data protection law in general, is that there are a number of places that are not practical from a company operational perspective, and we just have to get past them. Having a data transfer mechanism in place now, and also thinking about it vis-a-vis third parties, is very important. So. You know, there are lots of service providers in the space that are already set up to be able to transfer data freely, because sometimes we do remote investigations where we access systems remotely, and we need to be able to essentially transfer data. When you access data say from the United States that is sitting in Europe, that is a data transfer, and there are data transfer restrictions. You need to work that out in advance so that the data can be transferred back to the United States or viewed in the United States to do the forensic investigation. Do that in advance. So, the data controller needs to document all personal data breaches. That's a requirement of the GDPR. We are now finding that in many member states, there are breach reporting forms. So they are many pages long in some cases, and they're tricky because the way you answer those questions will live with you for time immemorial. And remember, this is a moment in time when we know nothing. So you have to be very, very careful in answering the questions in these questionnaires. We've been told by DPAs, some DPAs in Europe, that they're really focused on the ones that are labeled high risk, not the ones that are labeled low, and medium is, you know, on the edge. But certainly, if you label something low and the DPA looks at it, the Data Protection Authority looks at it and says, yeah, not so much, it's going to be recategorized and you're going to be questioned about your ranking. Competing with the GDPR is the NIS directive, Network and Information Security Directive. This establishes really the first set of pan-European rules around cybersecurity. It applies to operators of essential services, what we would consider to be critical infrastructure in this country, as well as digital service providers. And there are breach reporting obligations, and there are security safeguard obligations to put in place. This is important to note, this is a directive as opposed to a regulation. The GDPR is a regulation, so it is automatically in place in all of the member states. A directive is only, needs to be transposed into local law, into member state law. So that is a process that's ongoing right now. It's not in effect in all of the member states as yet. There are three goals of the NIS directive. One is to make sure that there's a framework at the local level to implement the obligations in the directive. So we are likely to see cybersecurity gurus in each of the member states. There is a formalization of cooperation and disclosure among the member states. Of course, it's so critical. Information sharing is so critical, and you all know that very well. And there is an obligation among covered entities to report significant cyber events to the cyber guru who will be set up, and also to secure your systems. And just to give you a sense, the UK has now transposed the directive into law, and the penalties are very similar to the GDPR. They are up to 4% of global turnover. So this is a trend. Okay. Other global developments. In China, the Chinese cybersecurity law became effective last June of 2017. It impacts operators of critical information infrastructure and network operators. And I am told by folks in China that if you have two computers strung together, you would be considered a network operator. So this is certainly something to look out for if you do business in China, particularly if you have facilities in China. We are still waiting for regulations. There have been some that have come out, and others still yet to be issued. But this is something to watch, and I think it's really going to set the tone for Asia. So we're watching for some copycats. One piece of the cybersecurity law that I want to call out, in addition to breach reporting, so that's important, but there's also a data localization requirement. Data localization is just a terrible trend that we're seeing now across the globe. Vietnam just passed a law requiring data localization, meaning your data needs to stay in country. And that is a really tough requirement when you do business globally. You know, it is the World Wide Web, and it's named that for a reason. Very hard to operate in our global environment if data needs to be localized in country. There are breach notification requirements across the globe, and when we're handling a breach that affects 100 million user accounts, or in Yahoo's case, 3.5 billion user accounts, we're dealing with every single country. So we need to think about what countries' laws are relevant to our data breach, and we need to think about what our obligations are under those laws. And these laws differ. They are not the same. So we're always, very, very stressed, really, going out to local counsel, sometimes in 78 different jurisdictions, to try to figure out what the rules of the road are, and then trying to create sort of a uniform method of handling these events, because you can't have 78 different ways of handling an event and 78 different templates of letters. You have to manage this as you have to rise above and manage this from a 50,000-foot perspective. So it is tricky. So make sure you're thinking about different countries' rules. Okay. Let's quickly run through this timeline. Many of you in the room understand it very well, but there are some legal issues that I want to focus on. So once we identify the event, we pull together our incident response team, of course. We look to stabilize the systems. If there is an active intrusion going on, we're going to work really, really hard to figure out whether we should make ourselves known to the attacker and stop the attacker, or wait a little while. That might be more prudent, and of course Mandiant can help to identify what to do in an instance like that. We initiate the investigation. I'm going to talk a little bit about how to do that in a protective way in just a minute. We conduct our legal analysis. We draft the documentation that needs to be drafted to affected individuals, to regulators, to third parties. We may be working in this process with law enforcement. That's a decision point. It's a decision that needs to be made by the information security professionals, but also with counsel. Very important to have counsel involved there. We push out notification, and then you can bet that we're going to get a barrage of inquiries, initiating investigations from data protection authorities around the world and others. So not just the DPA, but other agencies as well may chime in, depending on the type of data. Financial data, healthcare data will likely trigger other agencies as well. And in today's environment, you can also bet on lawsuits. So there may be dozens of lawsuits that will follow. The hope is that you can consolidate them, certainly in the United States, but also overseas. We are seeing class action lawsuits in countries that we didn't really think had the ability to manage class action lawsuits. And at the end of every significant event, we absolutely should do a postmortem. Critical to do a postmortem. What did we do right? What did we do wrong? And how can we do it better next time? So hitting some legal issues. The very second you identify that there's an issue, please, please think about the legal considerations. And that means getting your in-house counsel involved or calling outside counsel. We want to coordinate with legal in getting law enforcement involved. There are considerations like, will law enforcement want to look at personal information of your customers? Not really. They don't really care about that. They care about the IOCs. That's what's of interest to them. But in looking at the IOCs, they might incidentally get some personal information, and that could trigger some liability. So we need to be very careful there. We want to make sure that we are preserving privilege. So typically, a law firm will retain a forensic investigator on behalf of the substantive client. And that way, at least we have a hope, not a sure bet, but a hope of at least a possibility of retaining privilege over the results of the investigation. So if you don't try, you certainly won't be able to assert privilege successfully. If you try, there are many instances in which we will have success in asserting privilege. We also want to make sure that we're preserving evidence in the right way. And there are certainly legal rules of the road and how to do that. Mandiant is very well aware of all of these issues, which we very much appreciate because we know that if we're not thinking of every jot and tittle, they are. So it's really helpful from a legal perspective. We may also want to issue a legal hold notice right off the bat, or soon after something is identified. If we think this is something really big and there's at least a strong possibility or a likelihood of litigation or a government investigation to follow, typically the General Counsel's office will push out a legal hold notice, meaning you can't destroy any information, you can't tamper with any information, change any information. So everything needs to be preserved. And insurance, cyber insurance, very, very many companies have cyber insurance now. The question always arises, when do I go out to my cyber insurer? Because once you do that, you're pushing an issue outside the organization, and there's knowledge outside the organization. So it's a tricky question. It's not always so obvious, but you also need to balance the notice requirement, and if you blow it on the notice requirement, you can bet that your cyber insurer is going to deny coverage. So it is a balance there, and we have found that insurers really are very good at maintaining confidentiality. They understand the business imperative around maintaining confidentiality, so we've had a good experience with that, but it's always a discussion point.
So in your experience, how effective is cybersecurity insurance? Because if you ask the community, I think a lot of folks, they're a bit skeptical about whether or not cybersecurity insurance providers will actually pay out claims, because they're a little bit burned from the automobile insurance industry or the healthcare insurance industry with all the pre-existing conditions. But from a cybersecurity insurance perspective, what are your thoughts? Does it work? Does it make sense to have?
Who does not have cybersecurity insurance? Wow. So does that, am I inferring from this that everybody has? Yeah, okay. So that's a complete sea change from a couple of years ago. If I had asked that question 5 years ago, two-thirds of the room, maybe more, would say, no, we don't have it. So, you know, it is rampant now, and in Europe, we're going to see, you know, this is an amazing opportunity for cyber insurers to go after the market there. But it's a rather mature market here. Do I think it's useful? Absolutely. I think cyber insurance has become rather critical for companies. Do insurers always pay out? No, but they do a lot of the time. And certainly the cyber insurers with the better policies work with their insureds, and they're working right alongside with you to understand what happens, so that at the end of the day, they will likely pay out, and we have seen that happen over and over again. So these are sometimes very good products. Sometimes they're not so good. It is really important to have counsel look at the policies to make sure that the policy that you're getting has no gaps or fewer gaps than other policies. They really do differ in their level of coverage. So I think it's important to have. The one other issue that I'll raise is that a number of insurers have panel firms to use. So make sure that the panel list that you get from your insurer has the law firm you want to use, the forensic investigator you want to use, the PR firm you'd like to use, the call center, the mail house, and the identity protection service you'd like to use. Very important to make sure that you've vetted those panel lists in advance and that you're comfortable with everybody on the panel. Yes?
On your last slide, you talked about preserving privilege. I presume you mean attorney-client privilege?
Yes. When I say preserving privilege, attorney-client and work product privilege, yes.
So the advantage of that kind of escapes me, not being a legal person, trying to keep all the results secret, is that the goal?
It's very good when a plaintiff's counsel is going after you and you're facing 42 class action lawsuits, and you don't necessarily want to turn over the results of your investigation to plaintiff's counsel, who will then have a better weapon for negotiating a very, very large settlement with you.
Okay. Legal maneuver.
Legal maneuver.
Legal maneuver.
Yeah, boy, that sounds sneaky. But you know, the other thing is that regulators are actually extremely respectful. Sorry, I just want to fix the mic. Okay. Regulators are quite respectful of privilege issues, legal privilege issues, and they will, if you say we did the investigation under privilege, they will more often than not say, okay, we don't want to go near that. Just give us a summary of what happened. And that's, you know, it's much better to be able to frame the issue carefully and not have to turn over a report. Which, by the way, could be subject, and this is what really drives regulators much of the time, it could be subject to a Freedom of Information Act request. So not only will the regulator have the report, but so will, you know, 52 privacy activists have the report as well. Okay. Yes?
Hi. On the privilege issue, with respect to the insurance companies often ask for the forensic reports. And if your position is that it's privileged, are you giving redacted versions, summaries, or are you just having them enter into NDAs and hoping that, how do you control the sort of waiver of the privilege? What is the general best practice there?
Yeah, very, very important question. How do we deal with insurers who ask for the forensic reports? The first question I'll pose is, do we need a forensic report at all? In many cases, we don't. And we get a verbal rundown of what the results of the investigation are, and that's good enough. And the information security folks can act on that information without having something in writing where we think that there may be litigation, there may be regulatory investigations that follow. So question number one that you should make sure to ask yourself. If there is a need for a report, for example, if you are a cloud provider and you have been attacked and 15 of your customers have had their data compromised and 5 of those customers are clamoring for and insisting on a report, then there is a need, there's a business need to have a report. We're going to work very closely with the forensic investigator in crafting that report. And it is not a privileged report. So we pull off, we know that we're going to be disclosing it, we pull off any privilege language on the report, and then we disclose that. But it is a carefully crafted report that is intended for essentially public disclosure. You should assume that anything that goes outside your organization is intended for public disclosure. Now, insurers are a little bit different. You can't retain privilege if you turn it over to an insurer, but I think you can also rest assured with at least most insurers that they're not going to turn the reports over to the media. So there may be a reason to turn a report over to an insurer, but more often than not, if you tell an insurer that you would like to keep the report under wraps because you did it under privilege, they will say, okay, no problem, give us a verbal report. So there are ways of handling this. Yeah. Okay. I'm going to race a little bit because I'm going to... Lisa, one more question. Sure.
What do you normally see as a best practice for, let's say, a company's communication or collaboration tools may have been compromised for out-of-band communication, and is that something that's very, that should be obviously considered up front in an IRP, but during that process then, if litigation comes, is that out-of-band communication then, within scope of the litigation?
That is such a tricky question. It's a great question and one we've really grappled with. So we have had intruders, and we've worked together on intruders that are in the system live. They're right there, and they're watching our communications. So we can't communicate using our normal channels. Do we turn to Signal or some other encrypted method of communication? Boy, we have a real issue with that with respect to legal hold, right? It's a real struggle, and it's a case-by-case situation. If we need to use encrypted communications channels to, for example, pass data from one information security professional in one building to another professional in another who's working on the systems, okay, use an encrypted channel, but don't write anything in an encrypted format that we think really needs to be preserved. So we are thinking about those sorts of issues. And it doesn't happen that often, but when it happens, this is something that we absolutely wring our hands over. So good thing to raise. Yeah. Okay. Do I have a minute and 15 seconds left? Or can I go a few minutes over? Sure. Okay. All right. When an incident occurs, we're thinking hard about our legal obligations. And so we're thinking about breach notification laws. We're thinking about industry standards, but we're also thinking about our contracts. Do we have non-disclosure agreements with our business partners such that the source code that they've entrusted to us, if it's compromised, do we have a reporting obligation to then let them know that the source code's been compromised? And if we let them know, boy, that goes outside the organization fast, and they're going to be pissed. So they're really going to, they're not going to keep this information super secret. Do we have SEC reporting obligations? So these are all the items that are on the table when we're dealing with a data breach. With respect to notification, as I said earlier, we have a lot of conflicting or overlapping laws globally. We have to think about that common denominator in drafting a communications document to regulators, communications document to or multiple documents to affected individuals, also to business partners, sometimes to employees. And all of this needs to be done very, very carefully because all of it becomes gospel. This is Exhibit A in any litigation, but it also needs to be done fast. So getting these communications documents vetted sufficiently within the organization quickly is really a challenge. We often hire third-party PR firms to assist with that because much of the communication that we're drafting is legally mandated. The content, even of a press release, is legally mandated. So there's not, we have a little bit of a tussle with the PR firm sometimes because they want to take out something where I have to say, no, I'm sorry, that's required by law. We can't take that out. I know it's not warm and fuzzy and you'd like more squishy language in there, but we can't. We need to say it this way. But there's certainly a cultural aspect to press releases and holding statements and media FAQs, and every organization has its own culture that should be reflected in these documents, and that's why it's very helpful to have communications help as well. I'm going to move on. After any breach of any size now, we can expect regulators to come after us. We can expect lawsuits as well. We might also face disputes with business partners, and certainly the insurer is, some of them are enormously cooperative and helpful. Others maybe not so much. So we might have a little bit of an antagonistic relationship with the insurer. All right, quickly, role of the board. The board is critical in cyber governance now. There have been a number of actions, which I will show you here, some of which have yielded some very good information about the board's role in cyber governance and their oversight responsibility. I'm just going to go back to this slide. The knowledge now of boards in this area is really fairly strong. For some boards, it's very strong. They have very, very good expertise, and they understand that their oversight duties include cyber now. Most often we see the audit committee having responsibility in this area with the full board briefed on a less periodic basis, but there's enough case law now for us to know that boards and audit committees have to be briefed quite frequently on this issue and should bring in third parties also. There's some precedent here to bring in third parties to give third-party independent views of the landscape as it might affect that company. Okay. So what we see in case law is that boards really need to understand what the crown jewels are of the company. They need to understand the threat environment and the specific threat vectors that are of particular concern to their company. What is the information security governance structure of a company? Who's accountable for information security? And what's the budget like? Is it decent? Is it good? Is it deficient? I've presented to many, many boards, and the big question that's always asked to the CISO is, do you have enough money? And it's really great for a CISO to present to a board and walk out of the board meeting with several million, many million, in some cases more than they walked in with when they came in. There needs to be very significant communication as between the board and management with respect to cyber, and cyber needs to be on the agenda, has to show up in minutes if you want to successfully fend off a lawsuit if there's a breach. Boards are going to want to receive benchmarking reports. What are others in our industry doing, and how do their security functions look? They are going to also want to make sure that they are, as I said, gaining the independent perspective and then documenting in minutes or charters that they have oversight responsibility for cybersecurity. Quick lessons learned. This is an issue that needs focus from the top. There is virtually no company now in surveys that doesn't put cybersecurity at the very, very top of their list of issues that worry them. This is always number one. There is absolute recognition everywhere by the C-suite, by boards, that this is a fundamental governance issue for the company, and senior leaders need to provide strategic direction. Because the bad guys are changing constantly, they are extremely pernicious, they are extremely sophisticated and increasingly audacious. There is certainly recognition that programs need to evolve. It's more a revolution than an evolution, frankly, in this space, but programs need to evolve to meet the threat. And I can promise you only one thing in this space, and that is preparation will mitigate harm. It will not prevent it, but it will mitigate harm to organizations. And I will stop there. Yes?
Hi, two questions for you, separate. One is, any view or comment on a recent settlement by Uber on the data breach notification that they just announced?
Yeah. So Uber just settled with all 50 states plus the District of Columbia for a very, very hefty
148 million?
48 million. Very hefty amount. That's the biggest we've seen. And look, the states are extremely active. We have to be very, very cognizant of the fact that these multi-state task forces form around cybersecurity breaches, and they will take action. And they have a lot more leeway than enforcers in the federal government or some other DPAs overseas have. So I think we're going to be seeing a lot of action from the states going forward.
What do you think their counsel was thinking when they decided to kind of bury that? I mean, what could they have been thinking?
I can't answer that question. Look, I was not their counsel. When a third party contacts you and says, I have your information, there's a lot of discussion that goes on. But the really easy part of the discussion is the legal part of the discussion, where counsel will say, the mere fact that they have our information means that data was acquired by an unauthorized party, and we have a legal obligation to notify, period. There's no debate around that. There's no gray. I'm not sure counsel was honestly consulted. I don't know.
Okay. Yeah. Well, from the news reports I read, they were directly involved in the decision not to disclose this, so I don't know. You don't know what's true, but second question, independent. GDPR, everything, and I'm not an expert on it, but everything I read about it as a security professional just, I don't know, irks me. It's really hard to envision this as being truly effective, but this 2% and 4%, global turnover, which is revenue in American, how does that impact, let's say, if the US government, it turns out, was subject to a GDPR notification and they didn't do that? Like, for example, let's say passports information was compromised and information about people who happen to be British citizens, dual citizenship was disclosed. Are they going to go after the US government?
Well, they can't, because there's no jurisdiction. So there are 3 jurisdictional triggers for the GDPR. One is you have an establishment in the EU, right. A facility.
Like American consulate embassy?
No, because they're immune, right? There's sovereign immunity. But if you have an establishment or you're processing data in the context of an establishment in the EU, you're subject. Or 2A and B, if you don't have an establishment and you're targeting European individuals, like you have a website that's in German, you accept euros as the currency for e-commerce, then you're targeting, that's indicia that you're targeting Europeans. You're in. Or 2, if you're monitoring the behavior of Europeans, you're also in. So, there are plenty of entities in the United States that are not subject to the jurisdiction of the GDPR. To the comment that it irks you, yes, I absolutely understand that. It's really, really hard. Quick historical context around the European rules. The Europeans come at this thinking of data protection as a fundamental human right because of the history of the use of information to persecute people, Nazi Germany, the Stasi, right? So there's a huge historical context to that undergirds the data protection scheme in the EU. We consider privacy in the United States to be a consumer protection right, not a fundamental human right. So just to put that, I'm not saying that it's, it makes it any easier to swallow, but putting it into historical context.
Yeah, in the context of the comment that irks me is not that, is more like this is going to be really hard to comply to, like the 72-hour notification and all these other details. I mean, somewhat unrealistic, to be honest with you.
Yeah, look, I think a lot of the GDPR is unrealistic. I think, we'd be hard-pressed to find any organization that's 100% compliant with it, which makes US companies that are really uber compliant generally very uncomfortable. European companies there's really a different sense of what needs to be done vis-a-vis legal compliance and complying with the spirit of the rules and making sure that you're making good faith efforts goes a long way. But US companies in particular are super compliance oriented, and it makes us very uncomfortable to have even a one T uncrossed. So.
Thank you.
Okay, thank you very much.